Right.
Welcome, everybody, as you come in. We're so happy to have you here. Welcome, welcome. Hi, Asha. Welcome, everyone. We're so happy to have you participating in this arbitration program that we've long promised. Welcome, everybody. We're so happy you could join us. Thanks for coming.
See, we have a few of our MBA ADR folks.
We may, not sure.
Oh, yeah, absolutely.
Okay, good. 1 minute to go, and then I'm going to hand it off to you, Lauren.
Sounds good.
Welcome, everybody. Welcome. We're about to get started. You got it, Lauren.
And we are starting promptly at 6 o'clock. Good evening and welcome to the Metropolitan Black Bar Association's ADR sections program entitled The Nuts and Bolts of Arbitration from A to Z, Part 1. My name is Lauren Jones and I am one of the co-chairs for the ADR section and will be the host for today's event. We're proud to present a panel with two arbitration titans who will be helping break down the beginning of an arbitration, how to prepare for it, and what happens before it actually begins. Whether you have never been in an arbitration or you're a pro, there will certainly be tips and tricks for everyone. It is now my distinct privilege to briefly introduce our panelists. Their complete bios are contained in your material, so in the interest of time, I will only hit the highlights. Ladies first. Ms. Verlyn Francis is an experienced arbitrator and mediator in commercial, civil, estates, family, and disability disputes. She is the principal consultant and the culture, diversity, and inclusion specialist at Isiko Dispute Resolution Consultants, Inc. Since 2015, long before this pandemic struck, Verlyn has used her technological expertise to conduct hearings by video conference. In addition to her independent arbitration and mediation work in Canada, she is a roster arbitrator and mediator on the global and general commercial panels of CPR, panels of distinguished neutrals, Financial Industry Regulatory Authority, also known as FINRA, and the National Bar Association. A guiding voice on ethics for lawyers, arbitrators, and mediators, Ms. Francis also teaches arbitration, mediation, and negotiation up to the master's level. She teaches at a number of institutions, including Centennial College, Humber College, LaSalle MC in Lyon, France, and Osgood Hall Law School. Thank you for joining us, Verlyn, or should I say Professor Francis?
Verlyn will do. Thank you.
Next, we have Dean Burrell. Dean is a nationally recognized labor and employment attorney and neutral. He gained his expertise as a litigator for the National Labor Relations Board as an attorney with major law firms, and as a senior Fortune 500 labor relations and human resources executive. As a neutral, Dean conducts labor and employment arbitration mediation, fact-finding, and workplace investigations. He sits on the panels of the American Arbitration Association, the New Jersey State Board of Mediation, FINRA, the Nuclear Regulatory Commission Whistleblower Panel, the Phoenix PERB, and the Arizona Department of Education. Dean has taught labor law at the Arizona Summit Law School and legal writing at the American University Washington College of Law. Dean is also the chair of the National Bar Association's ADR section, and if you know him, you know he's a proud graduate of Cornell University. Finally, moderating today's training panel is my co-chair, Jill Pilgrim, who is an arbitrator, mediator, and lawyer, and I will say an all-around consummate professional and great individual. Before we get started, just a few ground rules to bear in mind. There will be 2 CLE credits provided for attending today's program. The code will be read during the program and should be kept, as it will have to be provided following the program to get credit. Questions and comments are encouraged, but we do ask that they be placed in the question and answer box or the chat. For the most part, questions will be asked at the conclusion of the program, but if there are relevant questions asked about what a speaker is currently discussing, we will try to ask them when the topic is being discussed and covered so that it can be addressed then. And with that, I will turn it over to Jill to kick off today's training. Jill?
Thank you, Lauren. I'm going to ask the speakers to mute themselves when they're not speaking, and we'll remind you, welcome everybody, and thank you so much for joining us today. The other thing to note is that this is part 1 of a 2-part series. The second part of the series is going to take place on the evening of June 15th, at which time we have 2 alternate expert arbitrators, practitioners who are going to address the part of the arbitration process that begins with the hearing and goes through the written award. So part 1 is going to cover the first part of the process, part 2 on June 15th, the second part through the end of the process. And without further ado, I am going to ask Verlyn to share her screen, and she is going to start presenting on the pre-arbitration process.
Good evening, everyone. Thank you so much for attending. I'm going to be going through the material because, as you can imagine, trying to cover arbitration in 4 hours is a feat. So I'll be going through fairly quickly, but you have, I think the slides have been distributed already. So hopefully that will give you a chance to keep up. And as I said, if you have questions, put them in the chat later. So the demand for arbitration. So the demand for arbitration has grown exponentially as conflict and disputes have increased and become more complex, both domestically and internationally. At the same time, parties are seeking speedier decisions and confidentiality to protect their information. The result is that more disputants that previously would have litigated their matters in open court are now opting for arbitration as the preferred dispute resolution process. Probably the most important difference between litigation and arbitration is that arbitrators are very often subject matter specialists with many years of legal practice and procedure under their belts. Judges, on the other hand, have had many years of legal practice, but are usually generalists who must be educated on the subject matter of the dispute. That difference translates into litigation being a much more time-consuming and therefore more expensive decision-making process. In summary, time, expertise, and confidentiality drive the momentum towards arbitration, which can take several forms, including binding arbitration, which produces a conclusive decision in a dispute made by a neutral party called the arbitrator, of course. There's compulsory arbitration, which compels the parties to submit their dispute to arbitration for a binding decision. You also have final offer arbitration. That is, following a hearing, each party submits its final or best offer to the arbitrator, and the arbitrator must choose one. Grievance arbitration, sometimes referred to as rights arbitration, are used to resolve disputes concerning employment rights under existing collective agreements. You also have interest arbitrations, interest arbitration, which are used to resolve disputes concerning terms in a proposed collective agreement. Next, there are court annexed arbitration. So a court orders the parties to arbitrate and sets out the parameters for the arbitral process, including the selection of the arbitrator. You also have non-binding arbitration. This incorporates most of the characteristics of arbitration, but the parties are not bound to accept the decision of the arbitrator as binding. Ad hoc arbitration, which most people are aware of, the parties agree that a specific dispute will be settled by arbitration. Here, the parties determine all procedural matters, including the appointment of the arbitrators. You have what is sometimes referred to also as contractual arbitration, which arises out of a contract that provides that all disputes will be settled by arbitration. Documents only arbitration, where the arbitrator makes an award based on the review of documents only evidence presented by the parties. There is no formal hearing. So those are the different types. And I know sometimes people talk about arbitration as if it's one thing, but I thought I'd put those up so you could understand that when you ask for arbitration, you could ask for different kinds of arbitration. So what goes in to the arbitration agreement? One of the hallmarks of ad hoc arbitration is that the parties basically design their own procedure. The parties select the arbitrator or arbitrators who will decide the matter in the dispute. They also agree on the rules of law and the procedures that will apply. And they may also agree on whether the arbitrator's decision will be final and binding or appealable, and under what circumstances if it is being appealed. All of these matters are set out in the arbitration agreement. The arbitration agreement is defined, and I should pause here to say that my area is, as Lauren pointed out, mostly in commercial and civil arbitration. And so I will often refer to the international commercial arbitration, but I'll also refer to some of the local and national legislation. So the arbitration agreement as defined in Article 7 of the United Nations Commission for International Trade Law, everybody just says UNCTRA, model law on international arbitration, is that it's an agreement by the parties to submit to arbitration all or certain disputes which have arisen or which may arise between them in respect of a defined legal relationship, whether it's contractual or not. The model law has been adopted by numerous countries, and hence there is some commonality between the commercial arbitration law in most parts of the world. In the United States, for example, it is the Federal Arbitration Act. In England, it is the Arbitration Code 1996. And in Canada, it is the Commercial Arbitration Act. In addition, states and provinces have also enacted arbitration legislation. It is therefore important when drafting an arbitration agreement or clause to determine which law will apply to any dispute that may arise later. The arbitration agreement can be in the form of an arbitration clause in a contract, or it may be a separate agreement. Whichever form it takes, the arbitration agreement must be in writing. This requirement that the agreement be in writing is met by 4 ways. So it can be an agreement that is concluded orally or by conduct or other means. It can be by electronic communication, or it can be contained in an exchange of statements of claim and defense in which the agreement is alleged by one party and not denied by the other. That is one of the areas where people do get caught because, you know, a statement of claim is sent to you and they say, well, we're going to go by arbitration. If you do not deny that in your defense, then you have actually a turn to the agreed to that the matter, the dispute will be settled by arbitration. And another way that it actually writing the idea that it must be in writing is also confirmed, is that it can be also referenced in a document which contains an arbitration clause, provided the reference is such as to make the clause part of the contract. So when the original contract was made, if a clause was put in saying that all disputes will be settled by arbitration, then that is also an arbitration agreement if it was signed. So whatever form the agreement takes, it should include the following provisions: the governing law or proper law, the procedural law, so what procedures will be followed, and the number of arbitrators, the qualifications of the arbitrators, including but not limited to the language, technical training, and so on. You should include the language or languages of the arbitration and the place of the hearing. I think in the materials that already have been supplied to you, there are at least a couple of examples of arbitration clauses. And in my material, I've set out for you some links that you could follow. So how does an arbitration get started? Right. This is done by what is called the Notice of Arbitration. So the party who seeks recourse to the arbitration agreement, the claimant, communicates this to the other party, the respondent, through a notice of arbitration. The contents of the notice of arbitration must include the following: a demand that the dispute be referred to arbitration, the names and contact details of the parties, identification of the arbitration agreement that is invoked, you must mention specifically which agreement you're referring to. You must also identify any contract or other legal instrument out of or in relation to which the dispute arises. And if there is no contract, a specific description of the relevant relationship. So how do these 2 parties or 4 parties, how many of the parties end up in a dispute? You must make specific mention of that. You should also give a brief description of the claim and the amount involved, if any. You should also set out the relief that you're seeking and a proposal as to the number of arbitrators, the language and place of arbitration, if that was not already agreed to. In addition, the notice of arbitration may include a proposal for the designation of an appointing authority. So, that could be something like JAMS, it could be AAA, it could be CPR in Canada, it can be the ADR Institute of Canada, VANAC, in other words, ICC, any of these organizations. The respondent, once that notice of arbitration is received, the respondent is then required to respond to the claim's notice of arbitration within a set period of time, setting out mandatory and discretionary information, including a proposal for the appointment of an appointing authority or a proposal for the appointment of a sole arbitrator. At this stage, to permit the potential arbitrator to conduct conflict searches, which I'll go through in a minute, only the pleadings or the type of dispute, the names of the parties, their representative, and the major witnesses should be forwarded to the arbitral institution. Once the arbitrators are selected, further filings will be made without delay. Of course, the part that is most interesting is, how do you select arbitrators? How do they get selected? So since the arbitrator's task, like that of a judge, is to decide a matter in dispute, the selection of the arbitrator is a very important task in the process. The importance of the selection is even more important when the parties and their representatives take into consideration that the decision of the arbitrator is final, and in some jurisdictions, there is no appeal possible to the courts. For those reasons, arbitrators are usually chosen because of their known skill as arbitrators and for their subject matter expertise. The most I've over the years tried to compile a list, and borrowing for the list that I've prepared for today, I'm borrowing from the Hillary Lewis Rutley's model arbitrator competence. That has been adopted by the ADR Institute of Canada. And they include some very important skills, and some that are often missed by people going through the selection process. An arbitrator should have administrative skills. That is the ability to organize and conduct the practice of arbitration in an efficient and effective manner. And within that those administrative skills are included the ability to organize and maintain office systems, right? So setting up appointments, billings and all those things. It should also include the ability to work within the system rules governing the accepting and handling of cases. So, recording arbitration, appointments, etc. They should also demonstrate a clear understanding of the applicable Arbitration Act and ethics. And a third item that is included in administrative skills is the ability to allocate time, effort, and other resources, right? You're trying to work expeditiously. You want somebody who will be able to do it well. Another ability in the administrative skills, the ability to organize the required needs of the arbitration. So hearing rooms, ability to have private sessions so that parties can speak to their representatives, and then the ability to bring the case to a completion. All those I consider administrative skills. They should also have procedural skills, which encompass the ability to conduct matters using fair, flexible, and effective procedures. And those include the ability to clearly establish understandings, right? So understanding of the role of the arbitrator, define the rules, those types of things. And second one in procedural skills is the ability to determine legitimacy and jurisdiction. It's not unusual for an arbitrator to be called upon to determine whether they themselves have jurisdiction. That's sometimes referred to as competence, right? So whether the person, the arbitrator, has that ability to well, whether the arbitrator has the jurisdiction to be holding the arbitration in the first place.
So Verlyn, if I can ask you quickly, so how does an arbitrator determine whether they have jurisdiction or not?
Well, that might, then you look at the clause or the arbitration agreement. In other words, you're going back to that first bit that that we talked about what is in the agreement. You might also look at what, you know, does the agreement say that there should be, for instance, one arbitrator, or did it call for 3 arbitrators, right? Does it call for somebody with a specific language skill, right? And does the person who is now appointed as arbitrator, does that person possess all the things? Do they speak the language, for instance? So, you know, going back to the first things that I outlined.
So Verlyn, a person drafting, the corporate attorney drafting the clause can actually ask for specific qualities and attributes of an arbitrator.
Exactly. And that's why I set out, you know, in fact, that's literally why I know taking a lot of time to do this, but setting out the selection of the arbitrators to say, these are all things that you can actually look for. People very often just look at a name and they did some arbitrations before, but it's more than expertise, and it's more than knowing. It's all of these things that you should be looking at every time.
So since this is the Metropolitan Black Bar Association, can we ask for a list of arbitrators that includes diversity?
You can, you absolutely can. You know, that is, you know, and I encourage both counsel, both lawyers and their clients to actually ask. It is totally in your right to ask that the list of arbitrators that are sent to you, if you're dealing with an arbitral institution, include diversity.
There's been a fair amount of discussion. AAA will send out a diverse panel with at least 30% representation. However, what they've not publicized is that you can actually ask for an all diverse panel. Not every provider does that. FINRA, for example, randomly assigns cases. I would assume that there is a methodology for that. The FMCS, if the parties jointly request, I think will be able to suggest some names in an informal process. So I'm not sure that every panel is willing to do that.
It is very much, you see, what is important to understand about arbitration is that it is a process where the parties literally can determine all areas of the procedure, right? You can say, you know, the type of expertise you're looking for, the type of array that array is the panel. I mean, the list of arbitrators that get sent to you. Right, and more, I should say that more and more actual parties are saying, you know, we want decisions that are made by a mix of people. Okay, does that help you, Jill?
In this last segment, the last few minutes of this segment, can you talk about how an arbitrator deals with conflict of interest?
Yes. Let me go to,
Verlyn, if you could save a couple of minutes for me also.
okay. um, so, by the way, I mean, I've gone over because Lauren has asked that question. But all of those things that I set out, you really should look at. You know, interpersonal skills, by the way, is so important in selecting your arbitrator, right? They should be culturally intelligent, for instance. You know, that's why, for instance, I think we had that debacle with the Jay-Z matter, that, you know, cultural intelligence is what he was looking for. So it's not just that they are impartial. Lauren, before I go on to answer your question about conflict of interest, one of the things that you have to look for is that the arbitrator, your selection list should include people who are impartial and independent. That is, you know, one of the, if your arbitrator is not impartial and independent, it's one of the ways that your the other party will be able to, or some party will be able to appeal and actually end up winning an appeal.
And how do you assure that?
So let me deal with conflict of interest, and you'll probably get the answer in there. Okay.
Just a couple minutes in this segment. Okay.
Yeah, I'm going to take a little liberty myself. So
So
Go ahead. Go ahead.
So like judges and other decision makers, arbitrators are presumed to be neutral, right? They must be independent and impartial. In fact, in some of the laws, I know in the Ontario law, for instance, there's a prohibition against bias, okay? And this, I really want to make clear that I want to distinguish between bias and conflict of interest, because people mix them up all the time. So conflict of interest is financial interest in the outcome of a particular case, or more generally, any interest that is incompatible with the individual's function as a member of a tribunal. Sources of conflict or perceived bias, sources of bias or perceived bias include conflict of interest. So friendship with a party, dislike of one party, or prior knowledge of the facts that are prejudicial to one side. You can see how if you are biased, it's very unlikely that you'll be impartial, okay? And impartiality is the second, I call it the second pillar of procedural fairness, right? First pillar being the right to be heard and all the things that we know that go into procedural fairness. The arbitrator must be free of personal bias. They should not have prejudged the issues or have a predisposition in favor of one side or the other. That means that at the start of the hearing, they must have an open mind. They must reserve judgment until all the evidence and arguments are in, right? Bias, you can have actual bias, which is the prejudice is thought, right? How you think. Bias is how you feel. So you can have actual bias, that is the arbitrator's bias in the way they approach, or the other person can have a reasonable apprehension of bias, meaning the conduct that they have observed gives rise to their feeling that this person is going to be biased against me.
Dean, do you have a couple of comments on the issue of arbitration?
Yeah, I've got a few. I do.
A couple of minutes.
Well, I'm going to take a little liberty. I'm not a commercial arbitrator. Well, let me rephrase, because I've been doing some of that work. I started out as a labor and employment arbitrator. So my main specialty areas are labor, employment. I'm on the also in the multi-employer plan pension withdrawal liability panel of AAA, which is a small panel. Plus I do commercial cases for AAA, FMCS, et cetera. So the arbitration under traditional labor is totally different. It's a product of the collective bargaining agreement. Unlike the FAA, which was passed, I believe, 1903 or something like that. The traditional labor comes up as a result of collective bargaining, Section 301 of the LMRA, Labor Management Relations Act. And it was not until the early 60s in the Steelworkers Trilogy that it was recognized. And it's recognized primarily as the counter to the right to strike. There's a waiver for that. However, employment mediation or arbitration is very, very new. Most plaintiff attorneys are not happy with it and will oppose it zealously. So this conversation that we've had so far presupposes everyone wants to be in arbitration. In fact, they usually, on the plaintiff side in employment, they do not on the plaintiff side. This typically arises where you go to work for a company and you're filling out the new hire paperwork, and that's what comes. So you're going to see a lot of opposition to that from the plaintiff side. In the materials which will be going out, you'll see the statutory claims that the Supreme Court over time has found are subject to arbitration, Title VII, Age Discrimination in Employment, ADA, Americans with Disabilities Act, etc. However, employment arbitration at the state level is still fairly new. In New Jersey, where I practice, it was only in 2001 that the state Supreme Court recognized it. In this time, in labor, and I apologize for being disorganized, in labor, you can actually take the case to court for a very narrow set of circumstances if you're claiming that the arbitration award should be reversed. One of the large issues now in employment arbitration is who decides whether a matter is arbitrable as a threshold issue. So I would suggest that folks take a look at a case called Schein, SCHEIN versus Archer and White Sales. So that states that the arbitrator will determine arbitrability. I believe that was one of the questions you asked, which was who decides if the matter is arbitrable. The Roberts Supreme Court, frankly, has not met an arbitration clause that they didn't like. And as a result, arbitrators typically under the delegation clause that exists in AAA contracts, that exist in JAMS, are usually the ones to decide that. The other issue that you're seeing that's coming up in employment arbitration, particularly in wage hour class actions, is whether or not class actions are permissible. So as a result, there's been several important cases. The first one is Epic Systems versus Lewis that says that employers can ban class action. However, as the plaintiff bar threatened, be careful, you might get what you asked for. So there's a DoorDash case out of California in 2020 where something like 5,000 individual arbitration demands were filed. And the other thing which I'm going to mention.
Dean,
yeah,
we have a limited amount of time and we have a number
of topics
that, so if
I do want to, if
yeah.
you don't mind, I just want to finish up on
Sure,
the conflict of interest and arbitrated disclosure. In traditional labor, you have an absolute 6-month rule where you cannot have appeared as an advocate for any party. That is unique to traditional labor. In employment, you can actually be working for a law firm representing one side or the other and be an employment arbitrator. So each one of these has their own quirks. Jill?
Okay, sorry to speak over you. I want to make sure that we get to all the topics because there are a lot of people on the call who want to hear about everything.
Yeah.
And the information you provided is very valuable. So Verlyn, do you want to go to the pre-hearing procedures or would you like me to go to the video?
let me just say one thing, because this is really important about it all, that
Right.
arbitrators, it's for the arbitrator to look to see whether they have a conflict of interest, or to examine themselves, as they say, to see whether they have bias. And it is a continuing duty. That is really important for me to say. It's a continuing duty, whether you find something out, 3/4 of the way through or not, you have to disclose.
That's an excellent point. I once had a hearing where one of my co-arbitrators said that he had run into one of the parties in the weeks in between sessions. So we had him disclose that at the beginning of that session and ask the parties if they wanted to continue and waive any conflict. So that's an excellent point. So
And
we're going to go.
if you're going to waive conflict, please get it in writing, because when your award comes out, it's amazing how people forget that they agreed. Okay, thank you. Go ahead. Share the video, Jill.
And we're doing a lot of video arbitration, so it's recorded on video and on audio. So we're going to go to pre-hearing procedures now. Verlyn, I'll take my guidance from you.
Okay. Let me I'm working between two screens, so just give me half a second. Oops, I've gone to.
I will point out that this video that you're about to see is a product of the National Bar Association ADR section. And we are always open to new members. How's that, Verlyn?
Oh,
Verlyn,
you a shameless plugger. Go ahead and play the video, Jill. Go ahead.
okay, so you need to stop your share in order for me.
I'm terribly sorry. I'll do that right now. Yes.
Okay, what you're about to see is a small section of a longer video, which Dean preempted me in saying that we are thankful to the National Bar Association. I'm going to ask the panelists to mute your connection so we don't get any background noise while we're showing the video. So it's only going to be a small segment of a role play. Don't mistake the players, the actors in this small clip for real actors. So we're going to.
Hey, Jill, I'm not hearing the volume.
You didn't mute yourself, did you, Jill?
No, I don't think so. Is the volume not playing?
No.
It isn't? Okay, I haven't. It's not sure. Okay, we're going to have to talk through. Unfortunately, I'm not really sure why I can hear the audio when I'm playing it on my screen share, but for some reason it's not coming through. So go ahead, Verlyn, with your talking points on that, and I'll ask the rest. Yeah.
Okay.
I'll try to get it going.
So next, having selected your arbitrator or your arbitral panel, not panel, but tribunal, then the next thing is what goes into, before we get started, actual hearing, what happens? So pre-hearing procedures. There are two main purposes for pre-hearing conference. They sometimes referred to as preliminary hearings, pre-hearing conference, referring to the same thing. So there are two main purposes. First is to ensure that all the participants have a clear understanding of the matters in dispute and to establish and make clear the procedure to be followed during the arbitration. The preliminary pre-hearing sets the tone and process for everything that will follow in the arbitration. It is therefore very important that it be held as early as practicable and that the rules of the arbitral institution usually set out the time limits within which pre-hearing should convene. If there's no arbitral institution, then the arbitrator should convene the first procedural conference at the earliest possible date. Whether you are arbitration counsel or the arbitrator, I would highly recommend an excellent article that was written by Gerald G.Cass on the subject. It is at the preliminary meeting that the procedures for the conduct of the hearing will be determined. It is the opportunity, this is your first opportunity for the arbitrator to learn firsthand what matters the parties agree or disagree on and the extent of their differences. It is also an opportunity to get the parties to focus on the important issues and eliminate extraneous evidence or issues. While it is not always possible for the parties to attend, I personally think it's helpful to have the parties in attendance because it might be the first time that they have had to hear directly from the opposition what about their case. This might actually prompt them to look more favorably on negotiating a settlement to the dispute. If you're counsel, by the time you attend the pre-hearing conference, you should know your case and be ready to provide particulars, the details that will explain or clarify such matters as the grounds for a party's case, the remedy or decision the party is seeking, the evidence or facts on which you will be relying, clarification of the legal theory of your arguments, and so on. You should have a clear indication of the length of time that each stage of the hearing will take. And it is an opportunity also for you to start to show that there's clear merit to your case and that you're ready to discuss all aspects of the dispute. This means that unlike court actions where you file your pleadings and then prepare your case later, arbitrations tend to be front loaded. That is, a lot of preparation has to go into the beginning of the process, and you should prepare your clients for that because they'll be spending a lot of money upfront, okay? So before the pre-hearing conference, it is advisable for the arbitrator to deliver to the parties a draft agenda and to seek their input for any further items that should be included. The agenda ensures that all preliminary matters are discussed during the conference. And I have set out on the slide 19 for you, some preliminary matters that should be in the pre-hearing agenda. So when I say preliminary meeting, you're asking yourself questions like who should attend, when should it take place, should it be in person, by telephone or video, and so on. And at this point, you again emphasize confidentiality, which is of course one of the hallmarks of arbitration. It is here, Jill, as you asked as you asked earlier about the jurisdiction. If there's a question about jurisdiction, you want to bring it up at this point in the constitution of the tribunal. You want to be clear on the applicable laws and rules. So what substantive law was provided for in the contract? What's the procedural law of the seat? That is where the arbitration is situated. What procedural rules will be followed, and so on. The pleadings, are they complete? If not, you have to fix what is to be delivered and by whom at what date. Then you hearing, what dates should be set out for the hearing, what will be the length of time, location, etc. How are you going to provide the evidence, right? Are you going to use witness statements instead of direct evidence? And what time should those be? Are there going to be experts, right? Will the parties retain their experts, or should the tribunal retain its own expert? And how will the expert give evidence? Will there be hot tubbing? Will be a joint report? Set the schedule for delivery of the expert report, production of documents, pre-hearing, if they're going to be examinations, whether you're going to use interrogatories or actual examination. And, is the transcript going to be provided? All these types of matters need to be organized and discussed in the first or the preliminary hearing. And at the end of that, and I think, Dean, you wanted to speak to what should go, all of those things should go into an order. I think you wanted to say a little bit about orders.
Well, if you look in the materials, you'll see sample orders that I've issued in pension cases and in employment cases. And the parts of it are that are important. First of all, you want to have your discovery schedule set out. And that's the most important piece. You also want to know, you want to define when are dispositive motions due and what are those dispositive motions going to be. And I believe that I'll be discussing discovery and dispositive motions. So I'm not going to later. So I'm not going to spend a lot of time on that now. But take a look in the materials. I included a standard preliminary hearing and scheduling order for the consumer arbitration panel. I also included one, as I said, for pension. And that'll give you a sense of the types of things that we want in it, which also the parties may wish to amend their answer, or sometimes the parties may wish to amend their underlying arbitration demand. And that's something that you have to look at cautiously to make sure that they're not just expanding this beyond the scope of the original case itself. So Verlyn, I'll turn it back over to you with those high-level thoughts.
Thanks, Dean. One of the things that I should mention, because sometimes we think of everybody and we think of the parties, but arbitrators, you have to think of yourselves. So in other organizational and administrative issues, think about things like your deposit, right? What amount should it be and who will it be held by? What are your fees going to be and your expenses? What is your cancellation policy? With mediation and settlement and so on. Those are things that need to be discussed in this preliminary section of the hearing of the arbitration. For discovery, very quickly, all I would say on it is that it can include, can take the form of exchange of documents, examination for discovery, interrogatories, and so on. And as Dean said, that the order, there should be an order setting out. Once you have decided on all of those things and made your ruling, make sure it's in an order that is served on the parties.
Verlyn, we forgot about the most important part, which is determining the date of the hearing.
Oh, nice.
So
I
that
have
would
it in
set-
my, I have it in my list of
Got it. There you go.
yeah,
Where is it?
I'm sorry, I have it
Here. Yeah.
in my list of all the things you're going to be covering. I just didn't want to spend the time, but it is there. Those are
Okay.
all, you know, I highlighted some things, but on the slide that you have, slide 19, it gives all the things that you want to cover.
Well, let me ask you this, because when we were preparing for this program, you used a term that I had never heard before, which I really enjoyed, which I think was hot tubbing.
Oh,
I love that. And is that something you would handle during the preliminary hearing?
well, I'm going to talk about that in witness preparation.
Okay.
And so, you know, to describe what it is. But yes, those are all the things that when I said, you know, will the arbitrator be selecting their own expert, or will the parties, we can decide. So
Verlyn,
yeah.
I just want to, you mentioned an article, and is it in your PowerPoint, or can we get the article during your presentation a few minutes ago? You mentioned an article, and some
Okay.
of the participants are asking for it. So just, do you recall what it was, or if not, we'll get it to folks afterwards.
Do you mind if I get it? Just, it's, I'm not sure. I'm
Okay, no problem.
ambidextrous
Keep
enough
going.
to do it. I do have it. And
Yeah.
if you don't mind, maybe when
Yeah.
Dean is speaking, I'll put it in the chat. How's that?
Yeah, okay, good.
Okay, I will put it in the chat. It is a good article. Okay, so I wanted to go on to just quickly speak about witness preparation.
Actually, we according to the outline, I need to go into motion practice.
Oh, I'm terribly sorry. Of course, Dean.
Well, actually, yeah, we were going to try.
Started asking me about hot tubbing.
You're skipping ahead here. So we were going to try and play the video again. So let's see if we can get the video to work this time. Okay.
Okay.
So Verlyn,
I'll stop sharing.
Stop sharing, and
Yes.
yeah. Okay.
Revealed to you at this time. Therefore, I'm asking, do the parties confirm my service to you as the arbitrator in this matter?
Madam Arbitrator, as you are aware, the arbitration clause does require that in any matter over $100,000 that there be 3 arbitrators. In this case, the claim is for $475,000. However, Mr. Turpin and I have discussed this matter, and we do agree that we will proceed with a single arbitrator.
That's correct.
Okay, so I understand that you are both affirming me as your arbitrator in this matter.
That's
Right.
correct.
Okay. I've received, and prior to this initial hearing, read your claim, your response to the claim, your submission of documents, which included your arbitration clause, your contract, and your answer. I understand that this is an ad hoc arbitration utilizing the AAA rules, and the law governing this arbitration is that of the state of Maryland. If this is not accurate, please advise me.
That's correct.
That's correct.
Thank you very much. Today, you will schedule evidentiary hearing dates, set discovery, briefing, and motions deadlines, and address other preliminary matters. Therefore, you should be prepared to discuss the amount of time you will need to present your case, as well as your availability. Please have your calendars available. Have you at any time discussed between yourselves dates for this arbitration?
We have, Madam Arbitrator.
May I have them, please?
So, the first date that we have agreed on is that on the 20th of May, we will file our list of witnesses.
Mhm. And what date is the hearing? Let's go from the hearing and come back in. What date will the actual hearing be?
We are suggesting the 18th and 19th of August.
May I check my calendar? That date is available for me. You need 2 days, 18th and 19th of August. Is that 2021?
Yes, ma'am.
Thank you. And Mr. Turpin, you concur with counsel for claimant?
Yes, I do. Yes, we
All
do.
right, okay, thank you. Then we will start with the arbitration hearing will be the 18th and 19th of August, and the close of discovery will be May 20th. Is that correct?
Yes, ma'am.
Okay, all right. I want to remind the parties that mediation is an informal, voluntary, and non-binding approach in which an independent and trained neutral, a mediator, facilitates the discussion between you. It can occur simultaneously with this arbitration and will not affect the schedule which we set today. I encourage you to consider mediation at all times.
Madam Arbitrator, as set out in the arbitration agreement, we did enter into mediation. Unfortunately, we were unable to resolve this matter at mediation.
All right. I just want to remind you that should you at any time decide to pick up that mediation or start a new one, or however you would like to work on a settlement outside of this arbitration, let me know if you reach an agreement and I will put it in an award for you. So that can be done to your mediated understanding or agreement. In the preliminary hearing today, we must accomplish the following. The first we've already done. That's the statement that the parties accept me as your panel. You've accepted the rules and you've discussed the type of award. We've also discussed mutually agreeable hearing dates for consideration and a discovery schedule. Are there any anticipated motions? If there are no, I'm sorry. Yes, Mr. Turpin?
I was just going to say, we don't plan to have any motions at this
All
point.
right.
Okay, so that was a little bit of a snippet of our expert NBA member actors acting out part of a preliminary hearing conference call. We're going to try and get back on the schedule. And on the schedule, Dean was going to say something about discovery before he moved to motion practice. You're muted, Dean, so you need to unmute yourself.
Yes, ma'am. And by the way, I was enjoying that video. We will be putting that up on our NBA homepage. So it will be available for all to see. And the one comment I want to make about the section that we saw is every discipline of arbitration has its own process. For example, when I do traditional labor arbitration, when I get there to the hearing, or even in Zoom, when I'll pull the attorneys aside, I always ask, have the parties spoken? And I ask that because it is surprising how often they have not. And a simple 10-minute conversation will turn into a 2-hour settlement conference and the matter will go away. So that happens very often. And if they don't agree, for example, I'm on the Doorman's Union Realty panel in New York, I'll have the attorneys come in and sit down and just discuss their case with me, making it very clear that I can unring the bell. Whatever I hear doesn't exist if we go on the record. And usually after 5 minutes, someone will say, oh, I didn't know that. And when I hear that, I know the case is going to settle. Now, that's traditional labor. In pension, it doesn't work that way. And it doesn't work that way in the consumer panels either. The parties are fairly set in their way. In pension, because it is an outgrowth of labor unions and multi-employer pension plans, the parties may or may not be interested in chatting. So where I saw in this pre-hearing mediation was separate, it may not be. Now, here's the trap, and is that as the mediator, I have to make it very clear to the parties that I can unring the bell. And if either party does not want me to continue in the arbitration, usually because I figured the case out and one of the parties has figured out that they're not going to win, they may say, we don't want you to arbitrate. You know what? There's plenty of work out there. I will automatically recuse myself at that point. Verlyn, anything you want to add before I go into discovery, et cetera, and motion practice?
I was, the only thing I'd add to that, Dean, is that it's my personal practice that if I mediate something, I actually do not want to arbitrate, because in my view, I know people talk about, you know, a screen and that you can forget things. I think once you've heard it, and the whole idea of mediation, of course, is to have people really bear everything so that they can actually come to. And once they've done that, it might be evidence, it might be matters they wouldn't put in the arbitration. And, you know, once you've heard it, in my view, you can't unhear it and then make you know, a fair and impartial decision. So that's
Okay.
my view on that.
Fair enough. Now, going into motion practice, the first thing is dispositive motions. And I touched on this briefly before, but the biggest significant dispositive motion is arbitrability. Is the matter something that should properly be subject to arbitration, and who makes that decision? So it may be, for example, that the matter is not procedurally arbitrable. For example, one of the parties has completely blown the time limits. And then, as I mentioned, under the Harry Schein case, the question becomes who makes that determination? Is it the arbitrator or the courts? And at one point, there was something called the wholly groundless exception to arbitration, which meant that this case was so deficient that it should not be subject to arbitration. And that was one way of getting it to the courts. And that's what the Schein case cut off. So under the delegation clause of AAA, of JAMS, the arbitrator will make that determination. So you'll have, also you'll have fairly standard motion for summary judgment and motion to dismiss. And summary judgment may be whole or partial. I tend to view those cases with a bit of a jaundiced eye, because the whole idea of arbitration is for the parties to be heard. There is certainly a division of thought when I get together with my peers and we have these discussions. The question is, should the case be dismissed on procedural grounds or substantive grounds because the issue is not subject to arbitration? The other piece to it is compelling discovery. Now, discovery is different depending upon what forum you're in. Now, let's say we're in the traditional labor forum. There is no such thing as dispositive motions in traditional labor. We don't do pre-hearing conferences. We don't do any of that. The question is, when's the hearing, what time? And because of Zoom, I like to know who's going to be there for security purposes. Other than that, there is no pre-hearing issues in traditional labor. There's no motion practice in traditional labor. Traditional labor was meant to be an inexpensive alternative to the courts. And it is still, of all the different arbitration practices that I have, disciplines, it is still the purest form in that for that reason. Every now and then, an employment lawyer will wander into a traditional labor arbitration and start filing motions, and then I have to disabuse him or her of that ability. Now, in employment arbitration, we discussed some of the types of motions. Now, discovery in employment arbitration is governed by, for example, in AAA, under Rule 9 of the employment panel, the arbitrator shall have the authority to order such discovery by way of deposition, interrogatory, document production, or otherwise as the arbitrator considers necessary to a full and fair exploration of the issues in dispute consistent with the expedited nature of arbitration. What this means is that pragmatically, the arbitrator is going to be applying the federal rules or the state rules. And fortunately, as a litigator, I've dealt with this in the past. So if a party comes in and says they have to do 20 deps, my immediate question is why? And that's something that we resolved during the pre-hearing conference, because I want to know why do we need all this? Typically, you're going to have maybe half a dozen deps. And if you want to go beyond that, you're going to have a really good reason. The other thing is, what is the paper request? Now, I know we have metadata now. Emails are requested for significant periods of time and sufficiently and extremely broad. I'm going to narrow that down because I do believe that discovery should go to what is necessary for the parties to prove their case.
Dean, is that actually a key aspect of what makes arbitration different from court proceedings?
Yes. Yes.
Yeah.
I think it, and thank you for that question. It is a significant issue. When you're with a firm and you're doing discovery, you know, it's what I like to call the 18-wheel approach, which is every relevant document is included with the hopes that maybe the smoking gun is buried. Not that I would have ever done that, of course, mind you. But yeah, but in employment arbitration, what do you really need? Because and some of this, I won't say is self-serving, but I got to look at all that, or at least what's put in the record also. And I want a nice tight record in my case. I want to see what's important, not what's peripheral. So the dispositive motions in employment are not different significantly from federal or state arbitration, or rather litigation. However, traditional labor, when it comes to discovery, there is, again, no discovery in traditional labor. Instead, discovery is under the rules of the National Labor Relations Act, and the parties are obligated to provide what is relevant and necessary. The request cannot be unduly burdensome or broad. I don't have jurisdiction over that. Now, I will very often, where the parties are at loggerheads, offer, and I make it very clear as an offer, to hear it, to render, I won't even render an opinion because it's ultra virus, it's beyond the scope of my authority. I will endeavor to get the parties to agree on what should be provided and what shouldn't. If they can't agree, then they have to file an unfair labor practice charge under the National Labor Relations Act. That is going to push back the hearing quite a while. So the parties are really loath to do that. So that gives me some leverage in helping them work that out. Information request, subpoenas. Now, I included a subpoena in the sample materials, and every jurisdiction handles their subpoenas differently. And subpoenas are a matter of state law. So you can be doing a AAA case or an FMCS case, but I cannot enforce a subpoena. I don't have that authority. I'm not a duly constituted court.
So Dean, I just want to halt you because we have people with lots of different experience who are participating in this.
Mhm.
So are you saying that I, as an arbitrator, have the power to issue a subpoena?
I'm going to say yes, but how's that for an answer?
Yeah.
I was going to say that, you know, in most cases, actually, no, because for the reason Dean said that you're not, usually you ask the court to, and these are pretty routine, right? Ask the court just to issue the subpoena. It's not big arguments or anything. They are so accustomed to these, they will sign off on a subpoena.
So we're not in court when we're in arbitration. So in
Right.
FINRA arbitration, I'm issuing subpoenas. I'm issuing all kinds of subpoenas. So yeah, so I think we need to be careful because, you know, the most people consider arbitration outside of court, so you don't want to have to go to court. I know there are some circumstances in which you may be able to, but generally, in my practice, the arbitrator is able to issue
Right.
some subpoenas,
Yeah.
but then there's a whole body of arbitration law that talks about third-party subpoenas if they're not subject to the arbitration agreement. So I'll let Dean pick that all up.
Sure.
Can I, Dean, before you jump in, because I should have made a clarification that is really important that you you hit on, Jill. Here, as everybody knows, I'm in Canada, I'm in Toronto. So we talk about adjudication and we also talk about arbitration. Adjudication, so FINRA and so on, and other, we're acting on the statute. And that statute would sometimes give us the right to issue subpoenas. Ad hoc commercial arbitrations are acting under just an agreement. And that is usually the difference that you find in who can issue subpoenas. So yes, when I sit on adjudicative tribunals, I can issue a subpoena. But if I'm doing an ad hoc commercial matter or, you know, any other matter, then I can't.
In New York, for example, I believe is CPLR 7550. And I apologize to all you New Yorkers if I didn't get the right code provision. And every jurisdiction has its quirks. In New Jersey is covered under the New Jersey Uniform Arbitration Act. And some of it, you have to be very careful. When I used to practice in the tri-state, I could issue my own subpoenas in New York. I left the area for quite a while. When I returned, I believe that I have to sign as the arbitrator the subpoenas. I can't, as a party, I don't have the authority to issue a subpoena that the arbitrator has not signed. In New Jersey, it's different. The parties can issue a subpoena. They send me a courtesy copy, which is all well and good, but subpoenas are not self-enforcing, and then they would have to go to court to enforce them. Now, if I believe that the subpoena is proper and one of the party being served refused to comply, and their reasons are unsatisfactory, I will be asked to draw an adverse inference. I have not done it yet. I have used that as a bit of a club to, well, that's too strong a term. I have used it to suggest to the parties that they would be strongly encouraged to provide the documents that have been requested, or to provide the individual under a subpoena in personam that the individual be required to attend. So, Verlyn, anything that you'd like to add to that? I'm unfortunately a little bit ahead of the time now.
That's quite all right. Verlyn, you're muted if you're trying to say something. We have things to fill up the time, so don't worry, Dean.
Jill, I should mention that that article I put in the chat while Dean was working on.
Did you send it to everybody or just?
I think I did.
Okay, good. Okay.
But I might have just, so you might want to just check back maybe Lauren could check back in the chat to make sure it went to everybody.
So Verlyn, let's go to the witness preparation, and
I know you're dying to hear about hot tubbing.
Yes, there's somebody who wants to know about hot tubbing, and I was, since I learned about it from you, I think there are a number of people who are very excited to hear about witness preparation and hot tubbing. They think it's something sexy.
Well, let me share.
Verlyn, while you're finding that, I did want to mention, and I forgot to mention this, that as the arbitrator for motion practice, I will very often impose a page limit because you know how we are.
Mhm.
So it is important that the parties organize their thoughts. And I find that a 10 to 15 page limit will often accomplish that.
Totally. I agree with you. So when preparing your witness, the rules of evidence still apply, although sometimes relaxed in arbitration. Always keep in mind that an important attribute of arbitrations is that they take less time than the court action, and being economical with time means counsel or the attorney, depending on my audience, has to take a hard look at the evidence they'll present. So you'll have to ask yourself the usual questions to determine whether the evidence is admissible, is the evidence relevant, reliable, necessary, that is, what's its probative value, and is it fair? Right? The usual questions you'd ask yourself. So for witness preparation, the form of witness preparation depends on how the evidence will be introduced by the parties. Keeping in mind that the goal, again, and I keep saying this because it's really important, the goal is shortening the hearing. It is unusual to have, and again, I have to put the proviso, as Dean has said, depending on the type of arbitration you're doing, right? In commercial, it's unusual to have full examination in chief and cross-examination, as is usually done in court actions. So the following are some of the methods that are used. We have documentary, so all the evidence submitted in the form of documents, including electronic documents. And if this is the case, the document should be, as a tip for you, who are submitting, as counsel submitting evidence, the document should be well tabulated and separated by some means. I like chronologically, or you could do it by topic if there are several issues in dispute. The award of the arbitrator is based solely then on the documentary record. And this is appropriate, this documentary evidence is appropriate where the facts largely are undisputed and credibility does not appear to be an issue. It is, however, inappropriate where any of the parties is illiterate, poorly educated, or has limited fluency in the language of the arbitration. Second type is witness statement. So the witness's evidence in chief is in the form of a written statement that is served on counsel for the party opposite and filed with the tribunal. The arbitrator will direct whether the statement should be sworn or not, but it should be signed by the witness. The preparation of this statement is usually overseen by counsel, but you should be careful that the statement is the witness's recitation of the evidence in their own words. There is nothing more jarring and concerning than reading a witness statement and then hearing from the witness who sounds nothing like the document that is supposed to be their evidence. This could lead an arbitrator to doubt the credibility of the witness. At the hearing, the witness is cross-examined on the witness statement, and if new issues are raised in the cross-examination, then the counsel may have the opportunity to re-examine. Arbitrators often require that the witness's statement be accompanied by any documents to which a witness may refer during the hearing. A third type is electronic hearings. These are held through teleconference, or we're all very familiar with this these days, teleconference, video conference, right? So you can have video conferencing facilities and technology, but it should be sufficient quality to permit the tribunal to observe the witnesses and assess their credibility. Counsel might also advise their witness to make sure that their surroundings are clear of distractions. You don't want somebody trying to testify and, maybe the dog is running around or children are coming to get their attention, right? They will not do their best. So to avoid accusations though of coaching, the witness should be alone in the room from which they testify, or with counsel if that can be arranged. The fourth type is with expert witnesses. This is permitted as a result of a competence acquired through study or experience in a specialized field beyond that of the general public, right? Because we know ordinary witnesses are not allowed to give opinions. It is this expertise, if you will, this extra knowledge that allows what we call expert witness to give opinions in the arbitration. The role of the expert is to help the arbitrator to understand the specialized evidence. When deciding whether to engage an expert, keep in mind that some arbitrators are selected because of their specialized technical, scientific, or other specialized knowledge or experience. Just as an aside, let me say that if the arbitrator does not discuss it during the hearing, they are not allowed to use that specialized knowledge without having the parties make submissions or testify about it. So you have to be really careful about that. So expert reports should set out the witness's opinion and the facts on which they're based. The witness may be required to disclose in the report all studies, tests upon which their opinion is based. If you're using expert witnesses, you may require more lead time to identify the right expert with the appropriate experience to prepare and share their report with the other parties, identify the arbitral tribunal's special notice requirements or other rules related to the introduction of expert evidence. To decide whether or not the witness has the necessary expertise, the arbitrator may hold what we call anyway, a qualification hearing before deciding whether to permit the expert to give opinion evidence. In that case, the arbitrator may listen to the opinion evidence from the witness who is not qualified, or they may modify or dispense with the qualification hearing. In the award, then, the arbitrator may indicate that he or she accepted only reliable evidence and have rejected opinions based on insufficient expert knowledge. So you don't want to be caught in that trap that you think you have put in an expert, and then by the time the award comes out, you find out your expertise, your opinion from your expert didn't count. An exception to non-admissibility of opinion evidence is the evidence of, as I said, the expert witness. As I said, mentioned earlier at the beginning, an expert can be called by the parties, or in some cases, an arbitrator might actually have an expert right? Because neither party is willing to sort of go to that area. That expertise is needed, and an arbitrator might actually, but that's again, because it's something they'll discuss with the parties. So it's important to understand the obligations of expert witnesses, because sometimes we forget and they become advocates for one side or the other. So expert witnesses should be called to testify only in areas where their evidence is needed. If the expert is to assist, he or she must participate as an independent professional rather than as an advocate for the client. The expert should acknowledge any limitations and qualifications on their opinion. They should disclose any relationship to the party on whose behalf they are testifying. The expert should provide the tribunal with written reports or witness statements, give evidence in, if it's in English, plain English, avoid using jargon except in as necessary to properly explain the concept. So how do you evaluate the reliability of expert evidence? When deciding which evidence to accept, if expert evidence conflicts, so there's more than one expert and the evidence conflict, the arbitrator must clearly identify the causes of the uncertainty by looking to the standard of proof, usually a balance of probabilities in civil disputes. The party who has the burden of proof must establish the fact to the degree required by law. It is not necessary for the arbitrator to determine which expert is correct, but only to determine which of the conflicting opinions achieve the higher degree of certainty. If the tribunal can hire its own expert, it usually has rules about how it's done. So some of the factors to consider in evaluating the reliability of expert evidence: the potential rate of error, the existence and maintenance of standards, the care with which the scientific technique has been employed and whether it is susceptible to abuse, the presence of fail-safe characteristics, the clarity with which the technique may be explained, the nature and breadth of the inference drawn by the from the data, and the expert qualifications and stature. Okay. Witness panels, also known as hot tubbing or concurrent evidence. This is a format that is used to permit simultaneous examination and cross-examination of two or more witnesses where their testimony covers similar or overlapping subjects. The person cross-examining is given the option of addressing her questions either to the panel as a whole, that is, and then any witness can answer, or to a specific witness on the panel. So in other words, instead of one witness, you might have two or three, or how many experts you have, and they're sworn at the same time, and they're proverbially on the witness stand at the same time. So this is what's happening here. The arbitrator has a duty to allow the questioner to cross-examine on a topic as thoroughly as if each witness had testified separately, but the arbitrator has the right to prevent repetition of questions and answers. There are some risks to witness panels that and you might find this surprising, but one of the risks is that a more knowledgeable witness, because you're sitting there with the other parties, may defer to a less qualified or less credible witness. And a second risk is that witnesses may collude in providing consistent answers to questions so as to avoid revealing weaknesses in their own testimony.
So Verlyn, is hot tubbing used because the sense is that it saves time, or is it used because arbitrators feel like it gives a more honest view of the expert testimony, or is it something the parties' counsel suggest?
It's actually both of those, that it saves time. It actually, instead of putting to your witness, oh, expert A said this, what do you say about that, right? You have them all right there, and you might ask the same question, but
I've never seen this done in labor and employment.
it's not surprising. It's usually done in I call them commercial. So
No.
things where they're highly expert, these experts are usually of real technical things that, right? So an expert might have been called, and if they're on their own, their testimony would take 3 days, for instance.
Mhm.
So in the Deflategate case where they had experts, physicists come in and talk about spiraling of a football through the air based on the level of inflation of it, you would have had those two experts. It's very technical, scientific, or manufacturing stuff.
Exactly.
Yeah.
Exactly.
I actually tried to get, so after you described this, I tried to convince some parties to do this in a case involving a home inspection, and they were not amenable. But you only do this then when you have each expert. And one thing which I've seen done, and my mentor has done this in employment cases, where the parties will come in and discuss economic loss or emotional distress, etc., is he will have them review each other's report before the hearing and state where they disagree, and then just specifically address that disagreement in writing. Have you ever done that?
Yes, and that's one way of doing it. So they've exchanged. In fact, they often have anyway. It's not unusual for the experts to have exchange. One of the things that this is really good at is that tendency. Remember when I talked about experts should not become advocates?
Mhm.
It's too easy. It's getting more easy for experts. It's almost like, okay, we know this guy in California who is, a plaintiff side, whatever, and we'll get them, right? And what happens then is that the expert actually is more of an advocate. This is also one of the ways to curb that behavior, right? Because you have both experts there, and it almost forced each one of them to live up to their professional designation, with engineer, for instance, right? As opposed to saying, because the person is right there, right? The other side is right there. How are you going to say that the cement was properly constituted, right? If the other side is right there saying to you, you know what, here's how much aggregate went in and so on.
So we're going to segue into talking about what arbitrators do to prepare for a hearing. Obviously, witness preparation is on the party side, right?
Mhm.
They're preparing their witnesses. So Dean, you're going to talk to us about what is your obligation as an arbitrator? What are you doing? What amount of time do you put in, and how do you prepare yourself? And Verlyn, you can jump in on this too afterwards.
Well, you have to be careful. The first piece is be prepared. I will tell you, as a practitioner for a long time, there was nothing worse than an arbitrator who showed up. And some of this, I was actually listening to a panel that had compiled comments from practitioners from postal panels nationwide, both sides. And a lot of it is just some real basic things. It show up on time for the hearing. That's the first thing. It is amazing how often, as a practitioner, I would see arbitrators get there late, start looking at their schedule because they had to catch a flight out. I don't care. As I joke with the parties, they run at me by the day. Well, at least in labor cases. In employment cases and pension, they rent me by the hour. But I'm there to do work. So if it's an employment case or a pension case, I need to have read everything. And not only do I need to have read everything, but I'll ask questions. If I'm conducting a mediation or an arbitration and I get the pre-mediation statement from the parties and they've left some holes, and an unfortunate trend that I've seen at times are pre-mediation or pre-arbitration hearings that reference documents that they haven't included. Well, that's not doing me any good. So I'm going to go back and I'm going to say to the parties, first of all, I want to see every document that you referenced. And I'm going to read those documents. If it's an arbitration, obviously, I'm not going to have any ex parte communication. If it's a mediation, that's different. But not only will I request that, but also I read the cases. So what I ask the parties to do is, first of all, send me the cases, because I don't have all of those databases anymore since I'm a solo now. So I want to read the cases. Plus, I want you to tell me what page it's on. Because if it's a 60-page case, I don't need to go and hunt and fish. So I need to have done my prep work. I need to have asked for the mediation or rather the arbitration pre-hearing statements in advance, in sufficient advance. I need to have ensured that I have the time dedicated and that I've reviewed everything and I show up ready for a hearing. Now, in labor, all I have to do is show up for the hearing. So it's a little easier there, but the document review is crucial. Also, because I really do like the idea of we'll call it the quasi hot tubbing. How's that? Which is, I want the parties to have reviewed the other side's reports. I want to see summaries of it. I want to see what the areas of disagreement are. Now, here's where you have to be careful as an arbitrator. If I'm doing a federal case, for example, the Douglas factors are the Douglas factors in a federal disciplinary case. And if I'm doing a case that's on deferral, a discharge case that's on deferral from the NLRB, the right line test is the right line test. I know that. But very often, cases will rise and fall on obscure pieces of law.
Yeah.
And that's why I want to see the cases that are cited by the parties. Now, where I have to be careful is if I'm doing research beyond what the parties have given me. And this is something, and I know Verlyn, you're smiling because as a professor, that's one of the significant ethical issues, because I like reading cases. And if the parties, each side gives me their cases, how do I know what's the majority view? Now, remember, in arbitration, there's no such thing as stare decisis. But I have literally seen the same cases, especially if you've been on a panel for a while. For example, the 3028 teachers panel in New York, you'll see cases cited and you'll know those arbitrators and you'll see those cases, and I want to see what their analytical framework is. I don't need to know what their answer is, but I want to know how did they approach the issue.
What's the analysis, right?
Right. So I'm going to actually ask Verlyn, am I allowed, if it is an obscure point of law that is crucial, am I allowed to do my own research?
So, one of the ways that I approach that, if I happen to know that there is, a case that came out, you're right about ethical issues and being careful not to have your award set aside because you did, you went outside your jurisdiction, so to speak. What I will do is I'll say to both counsel, are you aware that this case is out there? And do you want to go and look at it and come back and make make some submissions on the issue, and the submission might be, Madam Arbitrator, it's not relevant,
Right.
and that's fine. But the issue comes in if I then take that case without letting the parties make submissions on it, right? Or, if I then factor that into my analysis, then, I've gone off the rails, right?
And actually, that's a good point. I was doing a mediation, and I do pension law. That's one of the things I do under collective bargaining agreements. And both parties sent me their pre-mediation statements, and they both missed this line of cases. So I sent an email to both parties saying, you have to address this. You have to tell me what's the answer here, because somebody's right and somebody's wrong. And be it an arbitration or a mediation, if it's a mediation, I'm going to use that law to leverage a settlement. If it's an arbitration, then one of the parties will know what the proper ruling is, and that may cause them to settle. So
Yeah, I want to make the point that this is a session on arbitration, and I don't want our participants to get confused.
Mhm.
It is a general rule in arbitration that you cannot address anything other than the evidence that's presented by the parties. However, as both Verlyn and Dean have mentioned, there are different techniques that arbitrators may use to, as Verlyn suggested, suggest to the parties that there may be something else out there that needs to be addressed. And we'll get into this in the second part of this, but the hearing in person is not necessarily the end of the hearing. So you can always ask for a post-hearing brief on issues, even if you're not going to be meeting in person again. Of course, now that we're in this video Zoom age, you actually can jump back on a call for a post hearing like argument on something, but we're not in mediation, and mediation and arbitration are two separate animals. So I do not want us to get our participants confused who are not familiar with either or one of the other. So in arbitration, you're deciding the case based on the facts and law presented by the counsel for the parties, and you are not to go beyond that.
Well, and here's why: when we're discussing post-hearing briefs, I specifically tell the parties, here's what I want addressed, in addition to whatever else you would plan to address. Because by that point, I usually do have a sense of the law, and there may be specific law to a given jurisdiction, but under AAA or whatever other body, the law of that jurisdiction may or may not be important. So if it's an ADA case, an Americans with Disabilities, I need to know, why is this an undue hardship? Tell me what the law is on that.
And this, I'll go back to the point that I made earlier. I know I sort of ran through them, but saying, hey, know what laws apply to the area, that you're dealing with. You really do have to know those things, and see right in your agreement. So this is for counsel too, to indicate which laws will apply to your arbitration. These things, I mean, I'm sorry, but it's a short program and we had to run through it quickly. But those things that I set out originally are really important.
And that goes to your earlier.
We're gonna give the code for CLE before we go into the last segment of this part one, and then we're gonna do some additional Q&A in about 10 minutes. So Lauren, do you want to go ahead and give what the CLE code is for this first part one?
Sure. The CLE code is, are we going to use we can use the original one.
You are? Okay.
Hot tubbing. That is spelled HOT space TUBBING. Again, that's hot tubbing, HOT space Tubbing. Thank you.
Berlin, we've made you a star. How's that? I
It's not
love
me.
that.
I mean, it came out of Australia. The Australians started using it first, and it just, it's spreading. Okay.
But by the way, there was a point that you made earlier, Verlyn, which just came back to mind, which is that's why it's important when you're selecting an arbitrator that you select someone who knows what they're doing in that given area. I mean, don't pick someone who's done construction law all their life for an employment case. They don't know what they're doing, nothing personal. But if it's a labor case, make sure this person has practiced in that area or whatever your specialty area is. I'm going to go ahead and seg into the pre-hearing brief and exchange submission. And really, I wanted to focus in on this area because this is particular to Zoom. My experience is that in arbitration, the parties do not exchange their pre-hearing briefs, nor should they. It is also my experience, especially in labor arbitration and employment, that no party should be attempting to introduce documents that the other side has not already seen. To me, that is a discovery violation, and I am likely to grant a motion to exclude that document for that reason. So, but when you're doing Zoom, one of the things that I've encouraged the parties to start doing is to send me the documents in advance. Now, in a traditional labor case, no one looks at anything until the actual hearing. So I do this because I want the documents in my possession, because I like to sort them out, print them out. This is part of my preparation. I like to make sure I have everything in front of me, but I don't read because there's no reason for me to do so because they're not in the record. However, technical glitches are usually the primary cause around documents that tend to lengthen hearings. And the parties don't want to pay for a second day of hearing because there was something related to some document that the parties couldn't get in. So what I insist that the parties do is send me the documents, preferably numbered, and it could change during the hearing because not everything's going to get in. Plus, not everyone is going to want to move every document in once they see how the case is going. So please send the documents in advance. Do not serve the other side. And everyone has their own way of doing it. I ask that each document typically be sent as a separate PDF. Because if you send me every document opened up, or rather in one, then I have to open it up. I have to start reading. I have to start splitting things out. And it's a lot of extra time and effort. Plus, as I said, I don't want to read. So I tend to have some fairly particular requests. And this is actually, I cannot force the parties to do this. I view this as being outside of my jurisdiction. However, I strongly encourage the parties to do so. So Verlyn, I don't know if you have a similar process in the time of Zoom.
I always encourage everyone to exchange documents between you. So there's no, I should not be getting, first of all, you're calling, you're going to put me into a conflict if I'm getting material that the other side. So I want materials sent, and I want when they come to me, I want to see some covering that says it's gone to the other side too. And when all of those, I remember a little earlier, I said, when you put them into, when you have document books and so on, to have some kind of order. I mean, these things are really important not only for what I'm really forcing the parties to do at that point is to organize their material, organize their thoughts. Right, about how, I mean, the whole idea of arbitration is to save time and money, and you know, and to do that work, as I said at the beginning, right?
What I ask the parties to do now in fact finding, I do a fair amount of public sector fact finding in Jersey, and there's a lot of economics, and they have big binders. So I ask them to send everything to me hard copy. Regardless of Zoom or not. And
what
also,
about joint exhibits? Do either of you ask for parties to agree and just submit one set of things they agree on?
I do that a lot.
Mind. I was literally getting ready to say that I asked the parties to step to their exhibits to the extent possible. And if they can't, they can't. But there are occasions where the parties may actually find that a hearing's not necessary. To Verlyn's point, once they start organizing their thoughts, they may see that there is no facts in dispute, significant facts, and this can be decided on the pleadings. Or even if we have to go to a hearing, to have everything stipulated in where I can admit it all in one fell swoop really will cut several hours out of a hearing.
Yeah, I try to, you know, I very much stress the point that, you know, you're here to try to save money and time. That's the advantage you're offering your clients. And it's also, by the way, one of the reasons that I say, if possible, I like to see the actual parties, not just counsel who can be spinning stuff all over the place. You know, I like to have the parties at that first pre-hearing. It helps counsel, it forces counsel to sort of do things that they might not, you know, this getting too adversarial. This is an opportunity. And as I say, not to look, I was a lawyer for, you know, for a lot, I'm still a lawyer for a lot of years, you know, where you on one side, you're telling your client something to boost whatever they're saying. You know what, get everybody in that room and you hear what the other side's case is, and you suddenly realize, you know, maybe I'm not so, you know, I don't have that strong a ground on that point, right? And so then you can have a hard talk with your lawyers. So yeah, there's a little bit of strategy going on behind that first hearing. That is why I say that is a really important part of the process.
So we are going to encourage anybody that has any lingering questions about the first part of the arbitration process to put their questions in the Q&A. And then, and Verlyn's just sent the article information to everyone. And while you're doing that and thinking about your final questions, I want to give an example. In the materials, I think this is just sort of a fun, well, it's not fun for the person involved, but in the materials, there's an article, an Associated Press article, Swiss Federal Tribunal says doubts over arbitrator impartiality justified in Sun's Cass case. So I do a lot of sports arbitration, and the Court of Arbitration for Sport is actually an arbitration organization, just like the American Arbitration Association or JAMS, even though their name has tribunal in it. And there was an arbitrator. Sun is a Chinese swimmer who was accused of doping and had one of the first public CAS arbitrations, an arbitration that was open to the public. And on the panel of 3 arbitrators, there was an Italian arbitrator, and he was found guilty of doping and banned, I think, for 8 years. And then a little while later, they found that the Italian arbitrator had, prior to the arbitration hearing, issued tweets that were derogatory towards Chinese people.
Yikes.
So Sun's attorneys went in and got the arbitration award overturned on the basis that the bias on the part of one of the arbitrators, that from the beginning of the arbitration process, he was inclined not to find in Sun's favor. So that's a kind of an interesting example of what
You know, Jill, I can say that that is one of the most embarrassing things that can happen to you as an arbitrator. I mean, your reputation, you know, the people will still hire you because you have those prejudices, right? And those biases. And that's something else when I talked about cultural intelligence and so on, I know I didn't have a lot of time to go into that part of it, but that is really important because those biases drive, as I was explaining before, what we, what we end up calling just, you can tell it's 8 o'clock at night, right? That's just about when my brain shuts off.
Yeah,
we're conflict of interest, right?
Right,
We
right.
normally just go off and just say conflict of interest. But
Right.
what is driving, this is why I made that, I said there's a difference between bias and
And-
conflict of interest.
Yeah.
Included in bias is conflict of interest, right?
Well, yeah, I think that example is really more of a bias, right? There's no prior relationship with the party or his counsel. But in any event,
that bias drives the prejudging of the whole, or it again could lead to it's the ordinary person looking at those circumstances likely to think this person would get a fair
There's two questions in the chat, both of which I thought were pretty interesting. So
yeah.
why don't, the first one is from Kedia D'Souza, which is, do you recommend selecting a specific arbitration service, AAA, JABS, etc.? Some are better than others. Would you, what about selecting two services in your clause? In New Jersey, that issue actually came up where there was an arbitration clause in an employment case. It did not specify the provider, and it wound up going all the way to the Supreme Court, New Jersey Supreme Court, which grudgingly upheld not grudgingly, but they upheld the clause. That's very specific. I've seen cases in other circuits where it was specifically, the arbitration clause was specifically overruled, and the party was not compelled to undergo binding arbitration because it did not provide the name of the provider. So I would be very cautious about that. Whether it's AAA or JAMS, I mean, I'm not here to endorse one over the other. So I can't really answer that.
So would you say that was a poorly drafted arbitration clause?
Yeah.
Yes, absolutely, absolutely. And the party was lucky.
And frankly, even if there is not, because a lot of arbitrations are ad hoc, right? That the parties, after the matter has come to, that one party has filed and has sent a notice of arbitration, then they come together and decide, by whatever process, who to select. So you do not necessarily have to have an arbitral institution named in your agreement. It is for the reasons the fewer things you have to have a court decide or you have to decide at the end, right? A dispute is always more difficult to resolve when it is a full-blown dispute. You sort of make all the agreements when you're still talking to each other and you're great friends, right?
But as a corporate attorney who drafts clauses all the time, if you're not going to use an arbitral organization, you would indicate in the clause how the arbitrators
would be selected.
So that would be a deficient provision. So do we have another question we want to answer?
By the way, the parties, for example, in collective bargaining agreements, the parties all the time specify a permanent panel where they will say the names of the arbitrators. But that tends to be unique to labor. There was one other question which I thought was kind of fun. What if a party agrees to arbitrate as part of an agreement and then later refuses to participate? Frankly, I'm going to proceed. I'm going to decide the case on the basis of the evidence presented.
Yep.
And if the party refuses to show up, if it's the plaintiff and they refuse to participate, shame on them. I may ask the employer or the other side, do they wish to compel arbitration? That's up to them. But as far as I'm concerned, it's full speed ahead. Verlyn, I don't know if you have a different.
No,
take.
I agree that, you know, if you have an agreement, it's, the question would be, is the arbitration agreement, is it valid? Right? And if it is, you proceed, right? If one, just as in this case, just as in a court case, if somebody doesn't show up for court, then you are admitting the facts, as it were, you know, so be it.
Right. So just to be clear, whoever, regardless of if one party doesn't show up, it's the obligation and your duty as an arbitrator to take in whatever evidence or arguments the party that is there has.
Forward.
And
Yep.
then you're going to decide the case. And since you don't have any counter evidence, it shouldn't be a surprise. So Lauren, I'm going to hand it back to you.
Jill, let me just say one thing. It's not a slam dunk, by the way, that
Right,
person, the
right.
only person who is there will succeed, because if they still can't prove their case, you still have that obligation. Not you, but they still have the obligation to prove their case. And if they don't prove it.
Exactly. Right? You're right. Absolutely. A very good point. Very good point. Go ahead, Lauren.
Okay, and with that, thank you, Verlyn, Dean, and Jill for a very informative training panel session. Everyone, I think, can feel much more confident that they understand what happens before an arbitration formally begins, what options you have for selecting an arbitrator, and what an arbitrator expects of lawyers before a hearing starts. We also have a whole new appreciation for the word hot tub. And we'll so this was a great setup
on your deck.
This is a great setup, though, for part 2 of our training, which will be held on June 15th. And will feature 2 different arbitration veterans, Lisa Love and William Crosby. That training will focus on the actual formal arbitration proceedings, including how to deal with unruly counsel and the final issuance of an arbitration award. If you know someone who couldn't make it today but would be interested in attending part 2, please bring them along with you. And if you are interested in attending, please also be sure to register for that program, as the registration is separate from this part 1. Before we close out this evening, I would be remiss if I did not give a few thank yous. So thank you to our fellow MBBA sections, which co-sponsored this event, the solo and small law firm section, the civil litigation section, and the labor and employment section. And again, as Dean mentioned, thank you to the National Bar Association, who permit us to use the taped recording we saw earlier in the program. And finally, thank you, the attendees, for joining us this evening. We hope to see you at part 2 of this program. And please keep an eye out for the evaluation that will follow this so you can get your CLE credit.
And we want to thank our panelists, Verlyn Francis, joining us from Canada, where it's probably as hot there as it is here. And also to Dean Burrell, who's joining us from New Jersey. They're both in foreign territory to New York City, but I noticed that some of our participants are from all over the country as well. I saw Atlanta and some other locations. So, and I think some people have raised their hands. Are you seeing that, Lauren, that somebody raised a hand, a participant raised a hand? No, maybe not. Okay.
Real quick. First of all, I'm in Jersey by way of South Jamaica, Queens, New York, a fine graduate of Brooklyn Technical High School. But I did want to add that the National Bar Association Annual Convention is July 23rd to the 27th. The MBBA ADR section will be putting on a 4-hour CLE, our annual training, July 17th. We will be putting on a 4-hour ethics program if you need to get your ethics credit, July 31. We'd love to have folks attend.
So we want to thank everybody. Go ahead, Lauren.
I was just going to say, there is one person with their hand up, Robbie speedy. I'm not sure if we want to allow them to talk.
Sure. One last
Yeah,
question.
Robbie, yeah.
All right, Robbie, I'm going to allow you to talk. I think I've just done that. Are you still there, Robbie? Roby?
Robbie.
Robbie, yeah.
She's our parliamentarian, and Lauren, I would be remiss
Robbie, you're
if I didn't.
Okay, can you hear me now?
Yes.
Yes, we can hear you now.
This has been a really, really good session. And certainly the hot tubbing helped. And I think everybody will remember the session because of that, in addition to all the information they got. So very well done. Congratulations, guys.
Yeah,
Thank you.
thank you very much. Yes, the MBBA, I saw a question. The MBBA, this is recorded, this program. And I'm gonna, once we end, I'm gonna hit end the recording, but the MBBA has a YouTube channel and it has all of its CLE and other programs on the MBBA New York NYC YouTube channel. I think we also have an Instagram page and all of that. But I really want to thank, I'll give it back to you, Lauren. I really want to thank Verlyn and Dean because we're getting all these messages saying how excellent everything was. So Lauren, back to you.
That's it. I'm going to let everyone go. We're past 8 o'clock. So again, thank you very much for coming out. A link, I see a question is asked. A link will be provided to all that came to this program with the evaluation for a link for the next session. So keep an eye out for that and please do register and we will see you hopefully for part 2.
Okay, great. We're going to end now. Thank you, everybody. Have a great evening. By the way, Obama is on CNN now. So
Ah,
take care, everyone.
good
Bye.
night.